my lord,
We are challenging the
my lord,
project.
I'll demonstrate why writ petition is there. My lord, today, my lord,
The fact that the petitioner has already approached the NGT or has also taken the route of statutory appeal, whom we are not inclined to entertain.
my lords, allow me, my lords. I can't be left remediless, my lords. Today, if the NGT, my lords, today, my lords, today, if the NGT, my lords, today, if it is held that it is time barred, my lords, there will be no forum where the forest clearance can be challenged.
That appeal, we are listing that appeal.
My lords, what I am saying is, please appreciate, my lords, if my lords dismiss the WP,
To abuse the process
my
of.
lords, I am not abusing, my lords. I can't be remediless, my lords. It's a statutory tribunal, my lords, then.
NGT, not 70.
No, my lords, allow me, my lords have held, there are judgments of this court that allow me, my lords, there are, I wanted to press.
We can observe that this abuse of process of law, it will create problem in appeal also.
My lords, this is a genuine case, my lords. It relates to, on record, my lords, there is a report which says that coal block is allotted in an elephant corridor. There is a report of the forest department. I have annexed that. Now, my lords, what I am requesting is please consider this, my lords. My lords have in umpteen judgments held that statutory limitation for a tribunal will not debar the constitutional court from examining any issue. If today, my lords, NGT issue is held against me that is time bar, I'd be completely remediless, my lords. Delay, this limitation cannot held. That's why I'm saying, my lords, writ petition may be kept pending, may go along with this civil appeal.
Dismissed.
My lords may give me liberty to raise it before the appropriate forum. Otherwise, I'll be remediless, my lords.
Listing your appeal.
My lords, the seriousness is, please appreciate. If tomorrow it is held that NGT's view is correct that it was time barred, please appreciate that my NGT application is dismissed.
Thank you. Item 33.
My lords, my NGT application is dismissed. I am remediless is my submission, my
You
lords.
are not remedialist, your appeal will be heard by Justice Narasimha's bench.
My lords, but that's what I'm saying. If the
Hear your appeal, that's all.
if the court takes a view, my lords, with due respect, that it is time barred, then I am nowhere. I am remediless, my lords.
Therefore, you want to continue with one or the other blackmailing.
No, my lords, it's not. It's a report. I am just requesting that the report which should be taken into consideration.
So you want to us to lay down a principle that even if the appeals are time barred, we should entertain 30.
No, my lords, there is a settled law that if time, my lords, I am just answering my lord's query. Settled law that if there is a time bar for a tribunal, that will not debar the constitutional court from exercising jurisdiction. Delay and latches is the principle.
We will examine that part.
Lords, may I make a request? My lords may not dismiss the writ petition. My lords may just link it. My lords may not issue notice.
Sorry, dismiss, or at the best you can withdraw it, that's all.
My lords, withdraw with liberty to agitate if needed, my lords. At least that may be done.
Question of any liberty.
My lords, I'll withdraw it then, my lords. My lords, may I make a request?
Time and counsel for the petition, seek and permitted to withdraw this writ.
My lords, may I make a request? My lords? Can it be next Monday? Can it be next Monday? My lords have posted on Friday. Can it be next Monday? My lords have posted that on Friday.
When do you want?
Next Monday.
Next,
Friday is my sister's marriage. My lords.
next Monday.
Grateful.
No issue.
Grateful.
Please, Your Lordship. Your Lordship, this is a big online fraud that happened. And unfortunately, my foundation's account, some money was routed through my
There is a
foundation's account.
question of stopping from coercive action.
Your Lordship, as on today, 2 months have gone to jail. All the police officers from various states are behind me. They're coming to my residence. They are in court, Your Lordship.
How much amount has come to your account?
Only 10 lakhs in this FIR,
Only 10 lakh. Huh?
out of which 9 lakhs has already been given to the complainant by way of a
And
supervisor.
how many other people have been duped?
Your Lordship, this is a big fraud and I myself am a victim to the fraud. In Feb
That's it.
2025,
That may be true, but that's a matter of investigation.
very well, Your Lordship, but there are multiple state authorities that are behind me. Which forum should I approach to get anticipatory bail, Your Lordship? I'm in a very difficult situation currently. I'm a physiotherapist, Your Lordship. This is a charitable foundation. My only bad luck was that some amount got routed through.
You have done well physiotherapy of how many people? Throughout the country.
Your Lordship, the details of our bank account because of donations was available on the website. Our website had the details of our bank account.
These are all question of fact. There are serious allegations against you of duping people on pan-India basis. Better the investigation is conducted, but in any case, whatever defense you have, the investigating agency will examine it.
Your Lordship, it's not a question of defense. In fact, my only worry is, Your Lordship, because I am going to get picked up in all the other FIRs, which is from the same cause of action, Your Lordship. The cause of action is the same online fraud.
There is nothing like cause of action saying, if you have duped 10 people in the same modus operandi, that does not mean that only one offense you have committed. You have committed 10 offenses again.
Your Lordship, I'm relying on your Lordship's judgment. Your Lordship, I'm relying on your Lordship's judgment in State versus Khimji, Your Lordship. In this case also, the other FIRs were treated as 161 statements, Your Lordship. So there was only one primary FIR.
All right, show us where the mistake I have committed.
Yes, Your Lordship.
Which judgment are you referring
Your
to?
Lordship, State versus Khimji by Jadeja, Your Lordship. The judgment of this Honorable Court, Your Lordship. Your Lordship, para 20 of the judgment.
Where are the facts except that citing judgments and judgment? Where are the
Your Lordship, in this case also, Your Lordship may come to the initial paragraphs, Your Lordship. This reference was raised by the Sessions Court to the High Court. The Honorable Sessions Court had made a reference to the High Court, Your Lordship. And in this case also, 1,800 complaints were filed, other than the first FIR.
This
So-
case has nothing to do with your issue, madam.
Your Lordship, only on this point I'm relying on, that this be the primary FIR. All I
No, no,
seek is,
this is absolutely
Lordship,
irrelevant.
all I seek is interim protection. I'm a
Okay.
44-year-old man. I'm a physiotherapist. I'm running this charitable organization. Day in and day out, state authorities are at my residence, Your Lordship.
Just to entertain this petition made of dismissed.
Your Lordship, I may be allowed to withdraw the petition in that case.
All right, after arguing the case for some time, and consent for the petitioner seeks permitted to withdraw this. Matters को लगा देते. Yes, item 34.
Yeah, please, my lords. This is a similar case, my lords, in which 11 NCRP complaints of cyber
आपने
crime.
कितने banks को लूटा है?
Yes, my lord. My lords, he was just a mere employee, office boy. He was made a director. He was not even aware what all transpired behind his back. We've annexed his bank accounts also.
Can't entertain this.
My lords, at least some time may be granted for us to go and approach.
No, nothing.
Oblige, my lords.
35 Milud needs to be grouped with order at page 85.
88, same order. ये बोला ना, we proceed, but so, you should know. Huh? I should know to track.
And will stay on the course.
Same.
Great.
Lord, your lordship granted me indulgence. I went back before the Honorable High Court, my lord. Unfortunately, couldn't get heard fully, my lord. Only submission. One submission, my lord. One only submission. My lord, page 47, only one paragraph. The reasoned order passed by the competent authority why 17A was not granted. Only one paragraph. Page 47. Totally unblemished record, my lord, and please see 47, one paragraph.
That's right, but simple adjournment cases we are.
No, not adjournment. My lord, my term of MD, which, my lord, I'm today 56 years of
It
age.
is there on 15th May advance list.
No, I'm saying something else, my lord. I'm giving a very respectful suggestion. Kindly consider it. I'm 56 years of age. I am entitled to be considered and continued 5 years, 3 years, 2 years for a period of 10 years. My term by the central government, my lord, approved for MD 3 years in 23, which is coming to an end on 31st of May.
Delhi Special Police Act, Section 4A is inserted, saying that the Chief Justice of India will be part of the selection committee. Even a CBI director can be there, my lord, definitely, my lord, election, there is no question of inconvenience. All that we are looking for is an impartiality. We have a face, my lord, who, it's not that you cannot be removed, but who is appointed. That's why your lordship's collegium system, I'll come to those judgments, my lord. We must have faith in the person. And today, my lord, with great amount of respect, I don't want to say any disrespect, but there's slogans which are shouted in public meetings against the Chief Election Commissioner and commissioners, my lord.
is,
It's a
just a minute, Mr. Solicitor, we don't run away the facts. We do not run away from the facts. Yes, this is a constitution. It has to be seen, my lord. I have never seen, my lord, in a public meeting, Chief Election Commissioner, it pains me, my lord, that Election Commissioner have been said with words, my lord, which I don't want to utter in this open court. And meeting after meeting, why no action has been taken, my lord? It should have been taken. That party should have been banned, according to me, my lord, for saying so. It's a model breach of model code of conduct.
Some mob goes and, my lord, makes abusive words against the honorable judges. Lord, should we dismantle the collegium system? What is this argument?
Yes. What is this argument? Is the court for to consider? Mr. Solicitor, I am not trying to convince you. I am trying to convince the court only. What I am saying, my lord, with this also, no action is taken. Why should not the action be taken against that party? My lord, may I come to it now on page 93? Page 93 at 95.
We would appreciate that when one senior counsel is addressing us,
yes, my lord,
no one else should interrupt.
Grateful.
We are extremely grateful.
Yes, precisely.
Where else?
I was not going anywhere else.
We are there to check in. If he goes beyond his bounds, we will stop.
He had
Yes.
already, my lord. I am sorry. Anyway, he had already.
You know, in course of argument, Mr. Solicitor, you have been also in this profession for so long. Course of making submissions, sometimes you have to go a little here and there.
It is directly on the point, my lord. I'm saying whether we had confidence in a system where we are constitutional fathers thought that. Anyway, page 95, my lord. May I just go to page 95? Appointment of chief. This is by the, my lord, a committee, Second Administrative Reforms Committee, on the report on ethics of governance, etc., by the Government of India. At page 95, para 2.1.5, appointment of Chief Election Commissioner, Election Commissioner. The present procedure of appointment of the Chief Election Commissioner and appointment and the other election is laid down in 24, stipulates that they are to be appointed by the President on the advice of the Prime Minister. Yes. During the debate, page 96, in the Constituent Assembly on the procedure for appointment, there were suggestions that the persons appointed as Chief Election Commissioner should enjoy the confidence of all parties and therefore his appointment should be confirmed by 2/3 majority of both houses. Even at that stage, there were views that the procedure for appointment should be broad-based one and not confined to one person, my lord. Above all party consideration, in recent times for statutory bodies such as NHRC, CVC, appointment of chairpersons and members are made on the recommendations of broad-based committee. Thus, the appointment of Chief Vigilance Commissioner committee consists of Prime Minister, Home Minister, Leader of Opposition, whereas NHRC committee is chaired by the Prime Minister and its members, Speaker of the House, Home Minister, Leader of Opposition, Lok Sabha, Leader of Opposition in the Rajya Sabha, Deputy Chairman of Rajya Sabha. Given far-reaching importance and critical role of the Election Commission in the working of our democracy, it would certainly be appropriate that a similar collegium is constituted for the selection of, when you say collegium, my lord, it's from different fields. It can't be, my lord, the same person nominates one and then he appoints. Constituted for the selection of the Chief Election Commissioner and the Election Commission. Recommendation, the collegium headed by the Prime Minister, Speaker of the House, Leader of the Opposition of the Lok Sabha, Law Minister, Deputy Chairman of Rajya Sabha as members should be made recommendation as consideration of the President. It's similar to, my lord, Venkat Chelia Committee report. Now, what is important is, my lord, Law Commission of India, 255th report, my lord, which starts at page 98. CGI. Mm-hmm. 255th report, my lord, is on electoral reforms again. Page 99, para 6.1. The ECI is an independent constitutional body which has been vested with the powers of superintendence, direction and control of the preparation of electoral roll for as the conduct of all parliamentary state elections and the elections of the president of the vice president or so and so. 6.3. Article 324(5) of the Constitution intended to ensure the independence of ECI and free from external political interference and thus expressly provided for the removal of CEC. Removal is like the Supreme Court judges, my lord. Now the appointment part is, my lord, the recommendation, lordship may kindly come to, my lord, page 101. Recommendation, para B, appointment of election commissioner and CEC. Appointment process, the first it has been quoted. And now the final recommendation is page 103, para 6.12.1. Recommendation of the Law Commission. Given the importance of maintaining the neutrality of ECI and to shield CEC and election commissioner from executive interference, it is imperative that the appointment of election commissioner be a consultative process. To this end, Commission adopts.
Point 12.2.
Yes, my lord.
The recommendation is
to
that
12.2.
CJI should.
Yes.
One of.
To this end, the
Yes.
Commission adopts the Goswami Committee with certain modifications. First, the appointment of all election commissioners, including CEC, should be made by the President in consultation with the three-member collegium or selection committee consisting of Prime Minister, Leader of Opposition, and Chief Justice of India. The committee considers the inclusion of the Prime Minister as important as representative of the current government. So, my lord, this is, and then lordship would kindly find, my lord. So, my lord, lordship would see, my lord, before the making of the constitution, by the various committees, during the debates, and post the constitution, my lord, various committees from time to time have recommended that, my lord, it has to be multi-member committee, so it cannot be at the wishes of a single person, single individual, as the Act has provided. Now, in this light, my lord, the Constitution Bench in the Hon'ble case had dealt with the aspect at a great length, my lord. Would you now, lordship, take it up, my lord, the volume 3. Page 93 of this, because first I have given the two other judgments, Mohinder Singh Gill and T.N. Session. Page 93. Is, my lord, Hon'ble judgment by a Constitution Bench. Opinion delivered by Honorable Justice Joseph, and there is a concurring opinion by Justice Astogi. The judgment starts at page, my lord.
93.
93. The 144. Starts at page 144. And 147. So, just submissions of Mr. Gopal Singh Karnan are noted, my lord. And para 38 are this, lord, which I have read to you, lordship, lord. The historical perspective of the committees and the Constituent Assembly debates are there. And para 84 to 86 is important, my lord. Lordship would permit me to read that. Page 183. This page is not open. Para 84. It is clear that founding fathers intended that the elections in the country must be under superintendence, direction and control of an independent body. The body is Election Commission of India. Under Article 324, the Constitution, the Chief Election Commissioner is an unalterable feature or figure. A commission can consist of only Chief Election Commission, a multi-member commission was also contemplated by the founding fathers. However, the post of election commissioner was need-based. For nearly 4 decades, there was no election commissioner. As we have noted that on 1989, first 2 election commissioners were appointed. In that regard, the appointment of the chief election commissioner and the election commission, the constitution does not provide any criteria. It does not fix any classification. It does not prescribe any disqualification in the matter of appointment, either as chief election commissioner or election commissioner. The appointees have been bureaucrats drawn from civil services. 324(5) deals with conditions of service. Then para 86, the first proviso to Article 324(5) acts as a guarantee against the removal of the chief election commissioner, except on like ground, a similar manner, a judge of the Supreme Court can be removed. The conditions of service of election commissioner shall not be varied to his disadvantage. This means Parliament cannot, or the government by rules, either remove chief election commissioner except by impeachment in the manner provided for removal of a judge of the Supreme Court, nor the Parliament can make law, nor the government or rule vary conditions of service of chief election commissioner. The proviso to Article 325 operates as a singular insulation to protect the chief election commissioner either from being arbitrarily removed or his conditions of service being varied to it. But as contemplated by the founding fathers, the protection against arbitrary removal or protection against varying conditions of his appointment were not sole safeguard so far as far more vital was the appointment of the right man and the need to take out of the exclusive hands of the executive. But this is what the ratio of the judgment is, my lord. I'm just submitting. And now, Lordship, may kindly come to para 106, my lord, which is page 196. It deals with the cases regarding separation of power and judicial activism. And at para 111, page 197, separation of power has been held to be a basic structure of the Constitution. Page 111, Indira Nehru Gandhi is quoted, the principle of separation of power is not a magic formula for keeping the 3 organs. 112 is important, my lord. Separation of power is understood as prevailing in India, constitutes a part of the basic structure of the Constitution of India. See Keswanan Bharti. Then Indian Aluminium, adjudication of the rights of the party is an essential judicial function. Now, my lord, I will show to your lordship, my lord, the Election Commission exercise varied judicial powers also, my lord. So it has to be an independent person completely. And the appointment process has to be independent. The adjudication of rights of the party is an essential judicial function. The legislature has to lay down the norms and conduct of the rules which will govern the parties, and transactions require the court to give effect. Now, Roman 4, subpara 4 of para 56, courts in their concern and endeavor to preserve judicial power equally must be guarded to maintain the delicate balance devised by the Constitution between 3 sovereign organs functionaries, in order that they know that the rule of law permits to fulfill the constitutional obligations of establishing an egalitarian society, respective sovereign functions, etc., etc. Lordship may skip over that part, my lord. Lordship may kindly come to page 198, para 116. Separation of power is a part of basic structure of the Constitution. Equally, judicial review has been recognized as a form of part of basic structure. Judicial review of a legislation is expressly provided in Article 13. A court, when it declares a law by the legislature unconstitutional, if it be that it is within its bound, cannot be accused of transgressing the principle of separation of power. Declaration of a law made by the Parliament as unconstitutional form part of its power. In view of the enunciation of the doctrine of basic structure in India, unlike perhaps in most countries, even an enactment to the Constitution can be declared as unconstitutional by the court. Such exercise cannot expose the court to the charge that it is not observing the limits of the Constitution. Then Lordship may skip over regarding judicial review. Lordship may kindly come to para 186, my lord. Page 224. Para 186. What, my lord, what is important is that the court noted in Anukul that holding free and fair election constitute a basic feature of the constitution and approved of the view apparently that the right to elect is fundamental to the democracy. Even a treated as statutory right at any rate cannot be divorced from the or separated from the mandate of 326. The right is of the greatest importance and form the foundation of a free and fair election, which in turn constitutes the right of the people to elect representatives. We would for the purpose list the question rest here to process said. The democracy, my lord, the Dr. Ambedkar's speech is quoted, my lord. I have read to your lordship that, and lordship may kindly come to para 200, my lord, at page 229. Article 324 is a plenary provision clothing the article Constitution Election Commission with the entire responsibility to hold national and state election and carries with it the necessary power to discharge its functions. However, the Law Commission cannot act against a law framed by the Parliament or state legislature. The power of the Commission is also subject to the norms of fairness and it cannot act arbitrarily. The action cannot be mala fide. Article 324 governs in the matters not covered by legislation, being a high constitutional functionary which is expected to function fairly, legally. If he does otherwise, the court can veto the illegal action, say Mohinder Singh Gill. Now, my lord, 201, Election Commission under 324 can postpone election on the basis of the opinion that there exist disturbed conditions by the state, in the state or some area of the state, thus making of holding free and fair election not possible. This court followed Mohinder Singh Gill in democracy depends upon the man as much as the constitution. Election Commission is endowed with the power to recognize political party, to decide disputes arising from them. It can also adjudicate controversies or splinter groups within a political party. The right, this is, my lord, where judicial power comes, my lord. I'll show to your lordship later. The commission has also been found to have power of issue of symbol order. This site is traced to Article 324. Then, recognizing the magnitude of exercise of control is fair in election, this court declared that in case of conflict of opinion, the opinion between Election Commission and the government, as education of machinery to deal with the state of law and order, assessment of Election Commission was to prima facie prevail. This court no doubt observed that mutually acceptable conditions so and so. While dealing with the power of the Election Commission to the requisite staff for election duty, disagreeing with the commission, it could require the service of the employee of the Bank of India. This court declared the Election Commission did not have untrammeled power. The power must be traced to the Constitution. Election Commission has the power to issue directions to conduct elections, requiring the political party to submit details of the expenses incurred or authorized by them for the purpose of election of their respective candidates. The power was traced to the conduct of election. All the powers of election, though not specifically provided, but necessary for effectively holding elections, are available to the Election Commission. So 324 is the reservoir of power. Now, lordship may kindly come to my lord, para 207. From a spate of violence in the state of Gujarat in the dissolution of assembly, the commission took the view that it will not be possible to hold election, though 174 mandated there shall not be more than 6 months between. After finding that 174 did not apply to the dissolved assembly, it was indeed held that this court reiterated the words that superintendence, direction, and control and conduct of election were the broadest term. This court also found that there are no free and fair election. This is the end of democracy. Now, my lord, this is on the width of the power of the Election Commission. Lord, I have a separate chart, my lord. I'll invite your lordship's attention to that. Would your lordship now kindly come, my lord, para 213. 213. And 214, it's very, very important, my lord. To page 233, para 213. We would therefore find that the Election Commission of India has been charged with the duty and blessed with extraordinary power to hold elections to both Parliament and the state legislature from time to time. This is an enormous task. The power it possesses under Article 324 is plenary. It is only subject to any law made by the Parliament or by the state legislature. Undoubtedly, the Election Commission is duty-bound to act in a fair and legal manner. It must observe that the provisions of the Constitution abide by the direction of the court. The same being done, it can draw upon a nearly infinite power of the reservoir power of power once a poll is notified, which again can be called to be taken by the Election Commission itself and indeed capable of being misused and subject to considerable controversy if bias, subservience of the power, that is betrayal, it assumed unusual powers. Its writ lies across the government over the length and breadth of the country. Officers of the government who come under it charge become the subject to the superintendence of the commission. The fate of the political parties, its candidates, and therefore the democracy itself, to a great measure, is allowed to rest in the hands of the Election Commission. We may therefore be the officers